now.
Another policy item included in the budget that caused debate and delay are the proposed changes to the state's discovery reform. Under the new measure, prosecutors are required to prove that they exercise due diligence in submitting all evidence before a trial can take place.
Now, opponents argue that the measure would end some protections that prevent wrongful convictions.
It's going to allow us to get to the merits of a case a lot faster. It's going to cut down on unnecessary litigation, which for us here upstate was a giant problem.
Joining us now to give additional insight on the changes to discovery law, Bob Babcock. He's a lawyer specializing in criminal law at Tully Rinckey. Bob, thanks for coming on today.
Thanks for having me, John.
I want to do something the media generally doesn't do, which is kind of a broad look back to put this in perspective. Before they changed the law, what was happening with discovery laws? It felt like the complaint was that if you're a criminal defense lawyer like yourself, prosecutors were kind of dumping things on you late or close to trial date, and it wasn't giving you time, a proper time to form a defense. Is that what was happening before they made the first change?
Yes, those were the arguments that were coming from members of the defense bar, that we were not given enough time to prepare the defense if information was given to us at the last minute. Some of those claims maybe not were not exactly legit, because some of the things that were withheld that the defense bar used to kind of get a dismissal or get an extension may not have been truly relevant. But yes, those were the arguments coming from the defense bar.
So then they try to reform it, and like everything that seems to happen with the state, this is my opinion, not yours, they always seem to overcorrect. They try to fix it, and they almost go too far. Then we start hearing from prosecutors saying, well, now we're dismissing cases. Criminals are going free because you've got this tight window on us, and we're understaffed and overwhelmed, and that was the argument to change it. Is that what you were hearing before we had this last legislative session, that we got to fix it and sort of correct back the other way?
That's exactly right, John. I think your analysis is 100% correct. They reacted in a way that put such a burden on the prosecution in terms of their time frames that it really was unrealistic to expect district attorneys' offices across the state of New York to be able to provide everything that they needed to provide within those narrow time frames. So it was an overreaction, and it was a very, very narrow window for the prosecutors.
Well, the governor certainly fought to keep it in there when the budget was going a month late. I don't know how privy you are to what changes they've made this time around. Are you happy or comfortable, do you think, with what's going to come down your way as a lawyer with these, I guess, a second correction, tipping it back the other way a little bit?
Well, I'm hopeful that the reasonableness standard will be brought back into these matters and these considerations. I do think that some of the recommendations that we're waiting to hear the final language on are reasonable. I think they do make sense. I think anytime you're tying a policy into the relevance of the evidence, the materiality of the evidence, and a reasonable time frame to make that available, I think those are good things. In terms of the statements, there's a provision that says that they're trying to reduce the time frame of statements to the grand jury from 48 hours down to 24 hours. That's a small change that I don't think is going to have an impact. But I do think that the changes that are proposed in terms of what the defense can challenge and how they can come to the prosecutor and say, well, wait a minute, we don't have this. We're not going to wait to the last minute anymore. The fun and games are over. We're going to be reasonable, but we're going to bring this to your attention and say, listen, without this information, we can't possibly prepare a defense because we don't have critical information. So my hope is that it's going to create a more open dialogue between defense attorneys and prosecutors about discovery.
You know, what's interesting with the law is everybody watches, you get a rainy Sunday and you watch 7 Law and Orders in a row, and everything happens within an hour. And one thing they don't do well in that show is show the discovery process. They kind of skip over that. And that can take weeks to gather things together and share. How important is discovery for you as a defense attorney? I imagine it's important because they do have to an extent show you their cards, right, of what they're gathering against your client.
Very much so. We do not have surprise discovery in the state of New York. The prosecution is required to provide the defense with all of the information that they plan to use against the defendant. And likewise, the defense is required to provide the prosecution with fair, reasonable notice of all of the issues that they plan to raise at trial. So there is a fairness standard. As to your question, how important is the discovery? It is truly the lifeblood of the case. The discovery is the evidence in the case. Discovery can include everything from the body cam footage of the investigating officers, the statements that were made by the defendant or any of the witnesses to those investigators. The discovery can involve the property that was seized, locations, dates, times, timelines. It's critical to both the prosecution and the defense that the discovery be exchanged fully, completely, and that there be discussions about what is truly relevant and what is necessary in order to go forward in a timely fashion.
And if police are investigating a crime against your client and they find something that's going to help your client, do they have to give that over to you, or is it only if they write it down in an official report? Do you ever worry about that, where things that would help you you never know about because it wasn't shared?
Yes, 100% on that as well, John. You have to have everything that's favorable to your client under the Brady law in this country. Brady set forth an obligation where the government, any prosecutor's office across the nation, not just in New York, must comply with Brady by providing any information that may be helpful to the defense. So that's a consideration that needs to be made on the law enforcement side, on the prosecution side. And also, as evidence and discovery is ongoing, a case is fluid and it's going to change with time. And evidence can come in that is harmful to the defense, and of course we need that. But evidence can come in that is helpful to the defendant, and that's equally important.
All right, Bob Babcock, a criminal attorney, Tully Rinckey. Thanks for coming out. I wish we had more time. This is interesting, fun stuff to talk about, but hopefully we'll have you on after we get more details of exactly where this whole discovery change lands. Thanks for coming on.
Love to, John. Thank you.
All right.